Good evening, everyone. I'm delighted to welcome you all to our class on trials under labor law. In this power-packed session, we will delve deep into the courtroom dynamics of employment disputes and try to learn the critical nuances of trials within the realm of labor law. But from dissecting key trial procedures to navigating the intricacies of evidence and presentation, we will try to equip ourselves with the knowledge and strategies needed to emerge victorious in employment related battles. And to this end, I am honored to welcome Ms. Poonam Das, a seasoned expert in the area of labor and employment laws with over 2 decades of experience in this field. Ms. Das is a partner in the labor practice at Samagra Law and possesses experience with a wide array of practices within this area of labor and employment laws, including but not limited to advisory, litigation, and compliance. She was also previously a partner at Grey Matter Legal and has been a part of some of the most prestigious firms in the country. And I'm certain her insights today will be valuable contributions to our legal learning. It's a pleasure to have you here with us, ma'am, and I look forward to an interesting and enlightening session today. Thank you so much.
Thank you, Kashis, for that introduction. A little more elaborate than I deserve, I think. But nonetheless, thank you for that. And yes, welcome all for this trial class about trials under labor law. So there are two trials here. One trial of me and one about to learn for you to learn about trials under labor law. So should I start the PPT? Right. Thanks, Kashish. So we will be learning what are the trials available under labor laws. There are two kind of trials which are available under labor laws. One is industrial adjudication and another one is domestic inquiry. So when we talk about labor laws, uh, it's a wide statute or a compilation of statutes, I would say, when we talk about labor laws. I hope I'm audible. If I'm not audible, please let me know. I'll increase my voice. Uh, so when we talk about labor laws, it is wide statute. Is a compilation of lot of statutory acts, ranging from Trade Union Act till Employees Compensation Act. So it's around what I would say 26, 29 acts which compiles into labor laws. So here today we will be dealing with trials under Industrial Disputes Act, which relates to industrial adjudication. And when I say domestic inquiry, this is something which is done internally within a company to adjudicate some kind of a dispute within the employees or between an employer and employee. So first we will delve upon into industrial adjudication under the Industrial Disputes Act. So what do you mean by industrial adjudication under Industrial Disputes Act? So, in this, we will learn what is industrial adjudication and the process and techniques of industrial adjudication. So, Industrial Disputes Act is something which only deals with how to adjudicate industrial disputes. So, industrial disputes can be between employer-employee, employee-employee, and employer-employer. But generally, the cases which are referred to the courts are between employer and employee. So, what do we adjudicate? What is industrial adjudication? Industrial adjudication is adjudication of a industrial dispute. So, adjudication and settlement of industrial disputes as per the procedure laid down under the Industrial Disputes Act, which is generally called ID Act. So, in the court, rather than going on telling Industrial Disputes Act, we call it as ID Act. So, when we also draft the petition and plaint or the claim petitions, we refer it as ID Act. So wherever you go and we talk about labor laws, it is more of ID Act when it comes to industrial adjudication or trials. Like trials happen in criminal cases under CRPC, under civil cases under CPC, and in under the labor laws it happens under ID Act. So, what is the object of industrial adjudication? It is to help the growth and progress of national economy by maintaining cordial relationship between employer and employee. Why do we say that it help in growth and progress of national economy? Because If there does not exist a cordial relationship between an employer and employee, then there will be less of production, the productivity will come to an end, and the economy will also go down. So what we see here is that the strikes which we hear about, that the bank has gone on a strike, or the factory has gone on a the workers in a factory has gone on a strike. So what is happening? The work is being stopped. There is a stoppage of work. So when there is a stoppage of work, there is no productivity. When there is no productivity, there is no sellability. When there is no sellability, the economy is being hampered. So to help the growth and progress of national economy by maintaining cordial relationship between employer and employee is the object of industrial adjudication. So, what is the purpose of industrial adjudication? So, in the Supreme Court in Bharat Bank Limited versus employees of Bharat Bank Limited, early as in 1950, it was decided that in settling the disputes between employers and the workmen, the function of tribunal are administration of justice in accordance with law, confer rights and privileges on either party which considers reasonable and proper, interpret or give effect to the contractual rights and obligation of the parties, create new rights and obligation between them which it considers essential for keeping industrial peace. So when this case happened, when the since it's a bank, you can see when the bank employees went on a strike, so they all went into a court, and then the Supreme Court laid down these four principles that this is why we should settle the disputes between employers and the workmen. Why? Because administration of justice happens in accordance with law. So there is a procedure laid down in in every statute. In every statute, when I say in every statute, it is not limited to Industrial Disputes Act. In every statute, whether it's CRPC, IPC, CPC, EPF, that is called Employees Provident Fund, or Employee State Insurance Act, which is called ESI, gratuity, there is a procedure of administration of justice, how you are going to address the dispute. Under Industrial Dispute Act, there is a certain procedure. Under EPF Act, there is a certain procedure. Under ESI Act, there is a certain procedure. Under every act, there are certain procedures. So under ID Act, there is a certain procedure which has to be followed. Then confer rights and privileges on either parties which it considers reasonable and proper. It is not just that only one party will be benefited, but it will also, when you go for an adjudication, you have to see that both the parties are having equal benefits, or they are getting their rights and privileges determined in a justifiable manner, and interpret or give effect to contractual rights and obligation of the parties. So if there is an employment contract, employee and employer have gone to the court, and there is some clause of it which is not being enforceable, or which is not being interpreted properly either by the employer or by employee, then the court helps to interpret it. For example, non-compete clause. Now we know that there is always a clause which says that after termination of your employment with a certain company, the employee cannot go work with a competitor. So whether this kind of a clause can be interpreted in favor of the employee or against the employee, that is what we go to court to answer for answers. Then create new rights and obligation between them which it considers essential for keeping industrial peace. There are situations where you may not have asked for something, or you may not have prayed for something, and there must be a lacuna in the contract or the employment agreement or the service agreement. Then the court adjudicate that and creates a certain right, a new right or obligation, so that the industrial harmony and peace happens. This happens generally when there is a settlement between the parties, there is a mediation between the parties. Interpretation happens when you have gone challenging one clause of a employment agreement or a service agreement or any kind of agreement. Whereas creation of new rights happens when you are settling the matter. So the purpose of the industrial adjudication is four corners: administration of justice, conferring rights, interpretation, and creation. This arbitration, this is So the principal techniques of settlement of industrial disputes provided in the ID Act are, there are five legs to it. That arbitration has just gone inside the industrial adjudication. I don't know why. Maybe because it's small. No. So the principal techniques of settlement of industrial disputes provided in the ID Act are conciliation. Conciliation generally is a non-judicial method of doing it. It is prior to when you go raise a dispute. Second is adjudication. Again, what is done by the court. Then investigation, which is done again by the court or at the internal level. Arbitration is, yes, of course, Industrial Disputes Act provides for arbitration. It is just not that arbitration acts which provides for arbitration. ID Act also provides for arbitration between the workers and the employers. Generally, arbitration is not adopted between the workers and employers because the upper hand is always of the employer. So employer has more power when it comes to negotiation or when it comes to choosing an arbitrator. And since arbitration is a costly mode, so it is generally not adopted between the parties. So what is generally adopted, and then the fifth one is collective bargaining. So when we say collective bargaining, so it is when the trade union exists or a group of workmen exist, they get into a bargaining mode, and when they do it collectively, not a singular workman doing a bargain with the employer will not be collective bargaining. But when a group of workmen or a trade union does bargaining with the employer or with the management or with the company for for certain benefits or for certain changes in the service conditions, that is called collective bargaining. So when we do collective bargaining, there is more possibility that it enters into a settlement and then it is drafted into an agreement and it is signed by both the parties. So when you do collective bargaining and it is entered into a settlement, that settlement is sent to the conciliation officer for registration of that particular document, and it is valid for normally for 3 years. Normally for 3 years, and it has all the elements of the employment ranging from overtime, your working hours, leave policy, payment cycle, bonus, uniform, meals, lunch, or shift duties. So these are there. These are all the aspects of employment on which a trade union or a collective workman can do bargaining about. Then there is, as I was saying, arbitration. Arbitration is not generally exercised because it's a costly affair. Then investigation, as I said, investigation is generally internally done by the company rather than being done by the court. So investigation we will deal in the second part of it, but right now we will be dealing with adjudication. So, what is conciliation? Section 4 and 5 of the ID Act authorizes the government to appoint conciliation officer or a board of conciliation, respectively. Conciliation is a step prior to adjudication. It is compulsory to go through conciliation before approaching the appropriate court. So, if there is a dispute per se, an employee is terminated by the employer. The employee directly cannot go to the court under the ID Act. They have to approach the conciliation officer to conciliate the matter before going to the court. So, conciliation is a mandatory provision under which the employee has to go through. It's not necessary that there is a amicable settlement or or the desired result is achieved, but yes, you cannot overstep this conciliation. So, in case of an apprehended or existing industrial dispute, the conciliation officer tries to mediate and conciliate between the parties to reach an amicable settlement. A conciliation officer sends report within 14 days to the appropriate government, settled or not. Based on the conciliation report, the appropriate government refers the dispute to appropriate court with terms of reference if satisfied that there exist in industrial disputes. So this is the terms of reference is the is the distinctive part or distinguishing part of the labor disputes than civil disputes. So when you go to a civil court asking for the tenant to vacate the premises, or filing a case of recovery that so much of amount I have to recover from you, or filing a criminal cases is generally filed by the state. So in civil cases, you go and file a recovery that this much of money has is to be recovered from one person, or you have to vacate your tenant from your premises. You directly go to the court and file it. But here in Industrial Disputes Act, you do not go to the court directly. First, you go to a labor officer, labor commissioner's office. There you file a claim saying that my I have been terminated illegally by my employer, or my salary has not been paid, or my gratuity has not been given to me. Gratuity will go under, of course, under the payment of gratuity act, but the process is same. So there you go, you file it conciliation. Then the conciliation officer sends a notice to the management saying that a case has been a dispute, a industrial dispute has been filed by the workman. Please come and give your statement, file your reply. So once the management receives these notices, they go to the conciliation officer and they give their reply or they present their cases. Sometimes there is a settlement which happened within the before the conciliation officer, where the management agrees to take back the employee back into the employment, or sometimes a settlement, a monetary settlement happens, and the matter is not proceeded further to the court. But generally 90% of the time the management is not willing to take the employee back, because they have terminated them for a particular reason. The employee, when the management wants to settle the matter, employee generally doesn't want to settle the matter and they wants their job back. So most of the time conciliation doesn't happen, conciliation is failed. So when this conciliation fails, it is the duty of the conciliation officer to prepare a conciliation failure report and send it to the government matlab that the labor department, which deals with reference, which deals with cases which has to be sent to the court. So when the conciliation officer sends the failure report to the labor department, that it goes with a failure report which says that yes, there is an apprehended or existing industrial dispute, this could not have been conciliated, and accordingly the labor department takes a view whether it should be referred to the court, or it should be just ended there. So, if there is an industrial disputes in existence, the labor department sends the matter with a term of reference. So, where if it's about termination of an employee, then the terms of reference are whether the management has terminated the services of the concerned employee illegally or unjustifiably, or legally or justifiably. If yes, then what's the remedy? So this is generally the terms of reference which goes to the labor court. So what happens, that it is not the employee who directly goes to the court and files a case. It is through appropriate government. But now there has been an amendment in the idea which says, if the case is pending for 45 days in the conciliation, and for 45 days there is no outcome of the conciliation, then the employee can go directly to the court and file a statement of claim, rather than waiting for the conciliation officer to send a failure report to the appropriate government. However, here still the employee is not directly going to the court. It is going through conciliation officer only. They have to take a report of 45 days that yes, the dispute is pending for 45 days. So again, a letter from the conciliation officer has to be attached with the claim or petition to be filed in the labor court. So 45 days, if they, then they can go and file it before the court, saying that again they have to give their, in that claim petition they have to give all the facts and circumstances, and the notice will go to the management. So the difference between a civil case and labor case is that there is a terms of reference which goes to the court. Arbitration. What does arbitration under under ID Act look like? Section 10A of the ID Act provides that conflicting parties can agree to refer their dispute for arbitration to a arbitrator. Types of arbitration are voluntary arbitration, where both the conflicting parties appoint an arbitrator voluntarily on their own. The judgments of the arbitrator are not binding. Then there is compulsory arbitration. The government can force the disputing parties to go for arbitration, or both the disputing parties can request the government to refer their dispute for arbitration. The judgment given by the arbitrator is binding on the parties of dispute. So when it comes to section 10A, as I said, it is the discretion of both the parties. They can take the benefit of arbitration. They can do an arbitration, but the cost of arbitration is too high because they have to appoint an arbitrator. Once you are appointing an arbitrator, you have to pay a fees, like it happens under the Arbitration Act, Arbitration and Conciliation Act. So when if you are appointing an arbitrator, then you have to pay a fees. Generally, the employees, the labor class is not that well paid to appoint a fees. So this arbitration generally is exercised in the higher senior level of employees, although they are not covered under the ID Act. So when if there is a voluntary arbitration, right? I am a company, I'm an owner of a company, I terminated my employee. Then we both agree that okay, fine, let's go to a third party that will be the arbitrator. Like we do it in panchayat, let's do that. We will go to a third party, that person will be arbitrator. Whatever they will decide, I will be okay with it. But under law, under the eyes of law, that kind of a settlement or that kind of a decision is not binding. After that third party gives a judgment, I would say I am not bound by it. It has no legal sanctity. So voluntary arbitration goes then and there. Nobody goes for voluntary arbitration. For compulsory arbitration, again the dispute parties, they have to go to the government and say that okay, fine, you appoint an arbitrator. So people find it more convenient to go and raise a conciliation rather than I'm going and filing a application for appointment of a arbitrator. Although the judgment of that arbitrator will be binding, but still people don't choose the option of arbitration as settlement of their dispute or adjudication of their disputes. So here the Arbitration and Conciliation Act of 1996 is not applicable to Section 10A of the arbitration under the ID Act. So arbitration differs from conciliation in the sense that in arbitration the arbitrator gives his judgment on a dispute, while in conciliation the conciliator help the disputing parties to reach to a settlement. So arbitration is more about adjudication, conciliation is more about reaching to a settlement. There they are not, the conciliation officer are not acting like judge and giving any opinion or judgment on the dispute, whether the dispute is right, wrong. They're just trying to mediate and find a way out, a settlement. Let us go, let us leave your egos beside and just settle it, either by way of payment or by taking the employee on back on the job. So the ultimate legal remedy for resolving an unresolved dispute, industrial dispute, is adjudication. Adjudication, the way it is pronounced, it's adjudication. So we are adjudicating, we are deciding something. So it is the ultimate legal remedy for resolving an unresolved industrial dispute. Under the ID Act, an industrial dispute is referred with or without the consent of the disputing parties to the adjudicating authority by the appropriate government or state or central. So where the appropriate government, when we talk about appropriate government, that means which government has more stake in the company. So if it's central government, like in Air India, Indian Airlines, it was central government which has the more stake. So there the appropriate government is central. Then the matters go to a court which is appointed under the central authority, where the appropriate government is, where the The other, for other people, other companies, it is state government. So like private companies, it is state government. So in Delhi, the matters goes to labor court, which are situated in Rouse Avenue, whereas in Bombay, the matters go to labor court, which are there in the um, Chembur or something like that. So, under the ID Act, an industrial dispute is referred with or without the consent of the disputing parties to the adjudicating authority by the appropriate government, central or state. The industrial dispute is referred under the terms of reference to the appropriate court. The appropriate court must answer the terms of reference while giving the final judgment. So it is not like that terms of reference is about dismissal and they are talking about inquiry. So the court is bound by the terms of reference within the four corners of the terms of reference, and they have to answer that particular question. The question is whether the termination is illegal or unjustifiable. They have to answer yes, it is illegal and unjustifiable, and give reasons to that. So it's like more of a form of a question has been put to the court, and they're answering it while adjudicating whether it is proper or improper. So there is a three-tier machinery of adjudication of industrial disputes under the IDR: Labor Court, Industrial Tribunal, and National Tribunal. The Civil Procedure Code The Civil Procedure Code 1908 and the Indian Evidence Act are not strictly applicable to industrial adjudication. So they are applicable while filing the judgments or getting the evidence attested, or while filing the documents, whether it should be original or photocopy, but not in the strictest sense. The courts are very, very less technical when it comes to labor court, because the word labor court means they have been formed for the benefit of the labor. They're there to more of an assistance to the labor, because the labor class is not so educated when it comes to the class 4 category of employees, class 5 6 category of employees. They're not that educated, so the technicalities of the laws are not applicable in the labor courts. But whereas changing of the while changing of the situation and timeline, it is now that the judges who are being coming from civil courts to labor court, from criminal courts to labor court, there has been a merging of practices. There has been a merging of practices. Now they are more getting into the technicalities, and they are asking the people to be more compliant of CPC, which is Civil Procedure Code, and Indian Evidence Act. But there are judgments of Supreme Court which says that CPC and Indian Evidence Act are not applicable to industrial adjudication in the strictest sense. So adjudication is done as per the ID Act and rules thereunder and principles of natural justice. So labor court under section 7 of the ID Act, the appropriate government constitutes labor court for adjudication of the industrial disputes. So I'll go by an example here in Delhi. Since most my practice area is in Delhi, so in Delhi there are around 13 labor courts and two industrial tribunals. So industrial tribunals are those tribunals which there are two schedules under ID Act. So those matters which fall under Schedule 2 of the ID Act, that goes to Industrial Tribunal. So Section 7 gives the power to the government. It is not formed by the High Court or Supreme Court, but the government forms the labor court. So when Rouse Avenue has 13 labor courts, it caters to different district of the Delhi. So for Southwest, there are two labor courts. For Southeast, there are two labor courts. For South, there are two labor courts. For North, there is one labor court. So the labor courts are formed district wise in Delhi. The matter specified in the second schedule of the ID Act within the jurisdiction of Labor Court. So there is set Schedule 2 when you open the ID Act, and the last there is Schedule 1 and Schedule 2. Schedule 1 matters go to industrial courts, and Schedule 2 matters go to Labor Court. Here I would say that in case the Industrial Relations Code comes into comes into effectiveness or comes into operation, then this labor court and industrial court will merge, and there will be one presiding officer and one member like we have in consumer courts. But since it is not yet notified, so we will stick to ID Act right now. So labor court can also send the pending dispute with the consent of the parties to the mediation center of the court to explore the possibility of settlement of dispute. So if there is a dispute which has been referred, first we went to the conciliation fails and it goes to the labor department. Labor department has now referred the matter to the labor court for adjudication. Labor court still can again send the matter to conciliation or the mediation center of the court. So there is a mediation center in the High Court. Similarly, there are mediation centers in the Labor Court also. So there are mediators who have been appointed amongst the lawyers who are trained mediators. So they are given mediation, and the matters are referred there. It generally happens the mediation when the matter is referred to mediation. 50 there are 50% chances that mediations are successful. Either the workman is in need of money. Secondly, either the employer knows that it is financially viable to settle the matter rather than going on with the court hearings. Thirdly, lot of time has been passed by and the matter is pending for a long number of years. Then the workman and management both thinks that let's settle the matter and over it. At least one liability is over from our. So once you enter into the settlement mediation process, there is a chance that the matter will be settled and it will be over without even getting into that adjudication process. Then industrial tribunal, again under section 7A of the IDR, the appropriate government may constitute one or more industrial tribunals, permanent and temporary, for the adjudication of industrial disputes. Compared to labor court, industrial tribunals have a wider jurisdiction. The matters specified in the third schedule of the IDR fall within the jurisdiction of industrial tribunal. The industrial tribunal can also send the pending dispute with the consent of the parties to the mediation center to explore the possibility of settlement of dispute. So, what kind of matters go to industrial tribunal? They're more of like whether the condition of service has changed, whether the retrenchment has been done properly or not, whether there is the benefits, the benefits, the employment benefits, the payment benefits have been altered during the service conditions. So these are more wider jurisdiction, whereas labor court is only dealing with termination, domestic inquiry. Industrial disputes is all about, more of a more on those topics which has a larger impact on the workman category. The National Tribunal is kind of a very specialized body, which is again formed by the government. The seat is in Mumbai. It is not kind of a normal court. Those having national importance matter, those goes to National Tribunal. So this is one man adjudicatory body appointed by the central government by notification in the official gazette for adjudication of industrial disputes of national importance. The central government may, if things fit, appoint two persons as assessor to advise the National Tribunal. When a national tribunal has been referred to, no labor court or industrial tribunal shall have any jurisdiction to adjudicate upon such matter. Generally, National Tribunal is seated in Mumbai. Approval application in respect of workmen related to an industrial dispute pending before National Tribunal is filed before National Tribunal. So, what kind of cases goes to National Tribunal? I will give you an example. I have been party to, matlab, been a lawyer in such that kind of a case, and I have been to Mumbai. I've appeared before National Tribunal. So this case was about pilots and mechanical engineers working in airlines. So I was representing one of my clients, and there was a case going on which was regarding whether pilots and mechanical engineers are workmen under the Industrial Disputes Act or not, because they get a large number, but they get a huge amount of salary. The salary of pilots ranges in around 2 lakhs, 5 lakhs per month. Same kind of salaries goes to mechanical engineer. The pilots and the mechanical engineers, they kept on saying that we are workmen, because we are doing more specialized technical clerical kind of organizational kind of work, whereas the airlines people, matlab it is not just limited to Indian Airlines but also Air India, Jet Airways, these airlines people, they were saying no, these are not workmen, because they have decision making power. They know when to fly the aircraft. It is the only when a mechanical engineer gives a thumbs up, then only the pilot takes off the aircraft. It is the pilot who takes a call while in the middle of the air whether to do a landing in Delhi, or has to divert the flight to Ludhiana. So they have that decision making power. So that is why they are not workmen, and they are also getting huge amount of salary. So these kind of matters which has impact over the nation, but this is not just limited to one company, but the decision of these kind of matters will impact the nation as a whole, because every company or every pilot, every aviation industry will be completely um, impacted with this kind of decision. This had gone to national tribunal. So it was held by the national tribunal that pilots, mechanical engineers, technicians, they are all workman category people. They are not non-workmen, even though their salary is not a criteria to judge whether a person will be a workman or non-workman. And they are all doing technical, skilled, unskilled, semi-skilled, clerical work. These kind of decision making is does not make them a managerial person. So that judgment was again challenged in High Court, then in Supreme Court, and the Supreme Court said National Tribunal has adjudicated the cases properly. That hearing in National Tribunal cases went on ahead for around 6-7 years or more than that. So nature of disputes, which which are adjudicated by labor court and industrial tribunal, are industrial disputes relating to termination, retrenchment, unfair labor practice, closure, strike, change in service condition, etc. Prior permission to dismiss an employee or approval of dismissal, complaint against the employer or violation of section 33, recovery of money. The procedure followed in courts are: the terms of reference is set for adjudication. Notices are sent to the concerned parties along with the copy of terms of reference. Workman files the statement of claim first, as the onus is on him to prove his contention. So the principle is that whosoever raises a dispute has to prove that. So if I raise a dispute, I have to prove that something wrong has happened to me, not the other way around. So if the management says that he is not a workman, then they have to prove that he is not a workman. If workman says I am a workman, then he has to prove that I am a workman. So that is why when workman goes to conciliation, he has to file a statement of claim first. Then management files the written statement along with all the objections, facts clearly spelled out along with the necessary documents. Then parties lead evidences and address arguments. The adjudication authority passes an award or order as the case may be. So here, the in general parlance, it is called judgment by the other court. That civil court has passed a judgment, criminal court has passed the judgment. But under ID Act, it is called an award. If it is the order about dispute about termination, retrenchment, that is under section 10 or section 11, then it is called an award. But if there is a case under section 33, which is called recovery of money or approval application, when do we file an approval application? When we have to terminate somebody, then we have to take an approval from the court. Either we file an approval application prior to termination or after termination. Then that case, it is called an order. So that is the difference between award or order. Award is more specifically under section 10 when there is an, and for an industrial dispute reference case under section 33, which is directly filed by the employee for their recovery of money, it is called order. There is no appeal against the order or award passed by the labor court and industrial tribunal. So when we say appeal, appeal means you are filing it to a higher court which has the power to adjudicate or appreciate the facts and evidences again. You can, when you are filing an appeal, you have the right to file a new judgment or a new case law or a new document. new evidence. But under when we are challenging the award or order, that right is not available. So there is no appeal. However, the award or order can be challenged directly in the High Court. So when you file a challenge or a petition in High Court, it is called writ petition. It is called writ petition. It is not a normal appeal. So when you are challenging the award or order of a labor court or industrial tribunal, it is called writ petition. And in writ petition, you cannot file new evidence, new document, new grounds of challenging the order or new grounds to plead your case. Thus, it is important to build the case at the inception itself. So that is why when we go to the high court, there are certain cases in I have dealt with where the written statement has been made by the departmental person and filed in the court, and it is not pleaded properly. It is not, the documents have not been filed, and they go to the, when the award is against them, they want us to file a writ petition in the high court, and it really becomes very difficult to get those documents again on record at the high court level. So that was all about courts and tribunals under the ID Act, how they perform, how they adjudicate the dispute referred to them. So to sum it up, industrial under ID Act, Industrial Disputes Act, a workman has to go to a conciliation officer to raise a dispute regarding his either it can be settled there or it is referred to the labor court by the conciliation officer. The labor court gets a terms of reference from the department, from the labor department. The adjudication has to be happened within the four corners of the terms of reference. The workman files a statement of claim first, wherein he has to plead all his cases. He has to give all the facts and circumstances. When did he join the company? When did he was terminated? Why he was terminated? What he did? His allegations why the termination is illegal. Either resignation has been taken from him forcefully, either termination is illegal because he was not given notice pay, retrenchment compensation, or he was just let go of while as a senior while juniors were retained in the company. So he has to give the reasons why he thinks that labor termination is illegal, and the management then files a written statement. Then the parties lead evidence, so the workmen can get as many as witnesses as they want, and the management can also get as many witnesses as they want. But there is a cross examination which also happens, like we all see in the movies. It's not that fanciful cross examination, it's just simple question and answer. And the question is put to them, the document is shown to them, they agree either to the signature they have made, or they say that this is a false signature. So these kind of question answers are put to them where to prove the cases. Each party does that, and then the award or order comes. To sum it up, this is how what's the adjudication process under the ID Act looks like. The adjudication process under EPF Act, ESI Act, Bonus Act, Gratuity Act are different, but similarly, this is the process which is followed. There is a separate code from EPF Act, ESI Act, but for bonus gratuity, it is again the same labor commissioner who looks into the matter. The second part of adjudication under labor law deals with domestic inquiry and disciplinary proceedings. So, domestic inquiry is more of a private employment term, disciplinary proceeding is more of a government employment term. So, government departments generally do disciplinary proceedings, whereas private employees, employers call it domestic inquiry. So, ID Act does not provide for conducting domestic inquiry or disciplinary proceedings. However, the model standing orders under the Industrial Employment Standing Orders Act, which is applicable to selective establishment, deals with misconduct and inquiry. So, this model standing orders under the Industrial Standing Orders Act is generally applies to factory or mines or establishments having large number of employees, 100 and more. So there, that model standing orders provides a list of misconduct and the procedure how to conduct a domestic inquiry. There are ID Act, under ID Act, there is no mention of domestic inquiry. ID Act only deals with adjudication of an industrial dispute. So, the concept of inquiry has been developed on the basis of judicial proceedings and internal policies, service rules of the companies. So, when an employer comes to know about any misconduct committed by an employee, the following procedures may be followed. Principal in preliminary inquiry, suspension, issuance of a charge sheet, and reply to the charge sheet within the certain time limit. So this is a not a statutory procedure, but it's more of a court developed procedure. Lot of judgments have come down by the Supreme Court and High Court, and this procedure has been crystallized under in those judgments. So, if the explanation by the delinquent employee is found unsatisfactory, then inquiry officer is appointed to inquire into the charges leveled. The inquiry officer should be unbiased, impartial, and unconnected. The inquiry officer can be anyone within the organization, not an interested party, or someone from outside, including lawyer or retired judge. So, inquiry officer should inform the delinquent employee and the company about the time, date, and venue of the inquiry proceedings, not only at the start but at every date. So, what happens? How a company does a domestic inquiry? So, when you will read labor laws in your books, in your course, you will generally not come across any such situations. But to understand labor law or the industrial adjudication, this is important because there will be situations where you will be given a situation that a person is terminated or because has been issued a charge sheet of theft. Then an inquiry officer was engaged. Inquiry happened, charges were proved, he was terminated, he files a case. And when it reaches to the labor court, a preliminary objection is taken by the management in their written statement saying, I have conducted an inquiry. This should be adjudicated first as a preliminary issue. There you need to understand how this has happened, what has actually transpired prior to this. So when an employer alleges an employee of some misconduct, they have to first issue a charge sheet. Charge sheet is all about, it's not like the charge sheet filed by the police in the criminal courts. It is more exhaustive. This is not that exhaustive, but this has to be specific, not vague, clearly spelled out, the charges to be spelled out, and what and which provisions they have violated of their employee handbook or code of conduct. So charge sheet, within the charge sheet, either they are suspended, then a reply is filed by the workman, and if it is found to be unsatisfactory, then the management either appoints an inquiry officer from within the organization, who is unrelated to the workman, like not his departmental head, but a departmental head of some other department, or a lawyer like me who is appointed as an inquiry officer to inquire into the charges. Again, that inquiry officer then sits like a judge, although he doesn't have any judicial power, but he behaves as if he is the court of law. Again, the same procedure happens. Since here the management is the first to initiate the process, so management files a claim first in before the inquiry officer, then comes the reply from the worker. Whereas labor court, this process is definitely completely different. Matlab, the workman files the claim first, and then management replies. Here, in during the domestic inquiry or disciplinary proceedings, it is the management who files the claim first, and then the workman replies. So here, the management has to prove the charges first. Management has to prove his contentions first, rather than workman proving his allegations first. So the inquiry officer then gives chances to both the parties to conduct the cross examination, and then the inquiry officer gives a report. Whether the charges are proved, the inquiry officer does not give any findings or give any punishment, but he gives his finding whether the charges are proved or not. So the inquiry officer at every point in time, like if we go to the court, we get a date. So inquiry officer also has to give a date. Inquiry officer, if the in the court, when the one party is unavailable, is absent on certain date, then the court either sends a notice or they give another date. Similarly, inquiry officer also has to either send a notice or give another date and let the other party find out what happened in the court and the inquiry of domestic inquiry. But court, since court is a judicial body, it, even if it doesn't send notice, there is no obligation on him to send the notice. It is us to who find out whether what happened. We are under obligation, or the litigants are under obligation to find out what happened in the court. But while conducting a domestic inquiry, inquiry officer is under obligation to send a notice, because it is not a judicial body. He has to show his fairness. He has to show that he is unbiased. So that is why he has to send notices of next date of proceedings. Then again, the court gives 2 days, 3 dates. Similarly, inquiry officer also gets 2 days, 3 dates if one party is not appearing. Finally, the court proceeds ex parte. Similarly, the inquiry officer can also proceed ex parte and hear the case and give its judgment, inquiry report, which is called. Whereas in case of labor court, it is called award or order. So the word of caution, that, as I said, the charge sheet must be clearly describe the misconduct. The If there is a change in the charge sheet, then it has to be a supplementary charge sheet. It is advisable to avoid the appointment of company lawyer. Lawyer who conducts cases on behalf of the company as an inquiry officer is required to be neutral and impartial to both of the parties. Then procedure to be followed during inquiry proceedings. The inquiry officer should explain the procedure followed during the inquiry to the parties on the very first date. So what happens, even in the court, if there is a, since parties are represented by the advocates, so they know the procedure well. But in inquiry proceedings, the parties, the especially the workmen, they don't know. And in inquiry proceedings, advocates are not allowed, so they don't know the procedure. So the inquiry officer tells them the procedure. Even in court, when there is a new lawyer or a new worker, the judge takes the pain to explain the procedure, that you have to come with your witnesses, we have to come with your documents, you have to file your claim has to be filed within such a date, please provide a advance copy to the parties. These are the things which the court explains to the worker. Similarly, in the inquiry proceedings, these are the things which the inquiry officer explains to the parties, that it will be conducted in Hindi or it will be conducted in English, whether it should be written, whether it should be typed, then the language understood by the delinquent employee, then how to take the signatures. So, in the court, the appearance of the parties are marked by the steno in the order sheet. Similarly, here in the domestic inquiry, the appearance of the parties are marked by the inquiry officer. So if I am unavailable, then I pray for an adjournment, that your lordship may give me an adjournment. Similarly, before the inquiry officer, it is prayed that today I am not able to conduct the cross examination or I have not got the document, so one extra date should be given to me. So the inquiry office, so the procedure followed here is, inquiry officer should explain the procedure followed during the domestic inquiry to the parties on the very first date. Inquiry should be conducted in the language understood by the delinquent employee. Inquiry officer should record the proceedings and take signatures or acknowledgement over email over the parties on day-to-day inquiry proceedings. Copies of proceedings should be given to both the parties. Inquiry should be conducted as per principles of natural justice without bias and partiality. Adjournment should be granted on reasonable grounds by the inquiry officer. The party should be given opportunity to present and defend its case in accordance with the principle of natural justice. Inquiry officer can proceed ex parte against the delinquent employee or close the company's right after giving sufficient opportunity. So these are the principles which are very not very technical. These are the principles which are followed in the court also. The court also gives sufficient opportunity to the parties to present their case. They also take signatures on their cross examination. So when a party is cross examined, well, cross examination is a process where the company lawyer puts questions to the employee and they answer. It is written down by the steno, it's typed down by the steno of the court, and at the end of the cross examination, the workman has to sign that cross examination, and the lawyer of the workman also has to sign the cross examination sheet. That is an acknowledgement that everything has been typed correctly. So every time a question is being asked by the company lawyer and workman answers it, both the company lawyer as well as the workman lawyer reads the line which has been typed by the steno of the court, so that to assure and ensure that it has been typed correctly in the court record. Then there are documents in the court record which are confronted. So, what is confronted? When you show it to the other party and ask them whether this is the same document which was given to you during your joining of the employment, is this your signatures? Then, if the worker admits that it is their signature, then it is encircled and put a mark on it, and again it has placed before the court and exhibited. So how do we exhibit? What is exhibition? Exhibition of documents that happens even during domestic inquiry as well as in the court. So exhibition of documents is that you are relying upon certain documents to prove your case, and those documents are being marked by your name. So if you are a workman and it is the document of a workman and the workman is leading the evidence, then it is WW1 by 1. That is workman witness number 1 oblique 1 first document. So WW1 by 1. This is the general form of exhibiting the documents. So if it is a management witness, it is MW1 by 1. Management witness number 1 by 1. This is the same pattern which is followed in domestic inquiry also. So the labor court proceedings and the domestic inquiry proceedings may be just opposite to each other when it comes to filing of claim and reply, but the procedure which is followed both by the inquiry officer as well as the judge of the labor court is similar when it comes to exhibition of documents, when it comes to cross examination, and when it comes to giving of the award. So, adjournments to be granted on reasonable grounds, parties should be given opportunities. Inquiry officer can proceed ex parte against the delinquent employee or close the company's right after giving sufficient opportunity. So, ex parte is generally that person who is proceeded ex parte who is defending the case. So, in inquiry, the workman is defending the case, whereas in the labor court, it is the company who is defending the case. So, if the company official is not presenting himself in the court, then that company is proceeded ex parte. That means, with in his absence, the judgment or the case will be adjudicated. Similarly, here in domestic inquiry, if the employee is not coming, then the inquiry officer will hear the management, will take the documents and record and pass a order. So ex parte, if somebody who is defending, he is proceeded ex parte. Whereas if I am the complainant as a management or a workman in the labor court, then I am not proceeded ex parte. My rights are closed. My rights are closed, and after certain things, either the labor court in normally under CPC or CRPC, if the plaintiff or if the applicant does not appear, then the case is dismissed. But in labor court, the case cannot be plainly dismissed because they have been referred a term of reference. So the court has to answer that term of reference. That is why they just can't plainly dismiss the complaint or dismiss the statement of claim. They have to give a order on that term of reference. They have to answer that on merits. When I say they have to answer it, they have to on merits. So generally, sometimes what happens, the workman does not appear for 4 5 days and the labor court parts a no dispute award. What is a no dispute award? The workman has not appeared, he's not filed a statement of claim, so there is no dispute. So that is called no dispute award. But after a month, the workman finds out that, oh my god, my case has been proceeded, no dispute. So he comes back to the court and files an application for setting aside that no dispute award. Then the court is under obligation to set it aside because the terms of reference has not been answered by the court. So even the high courts have told that you have to answer the terms of reference if you don't want to reopen that case. So once both the parties have presented their case, the inquiry officer should submit an inquiry report, which is again labor court submits an award. Inquiry report should analyze the evidence and the reason finding should be given on the issue if the misconduct is proved or not. Similarly, the labor court also has to give a reasoned order and give its finding whether the termination is proper or improper, answer the terms of reference, and then if not, if the termination is illegal, then give them the remedy. Whether they should be taken back into the employment, whether a compensation is fair enough, whether the reinstatement has to be with the back wages. So, if somebody is terminated in 2020 and the case is decided in 2023, so when that person is reinstated back, when the person is reinstated back, then that person has to be given the back wages of those 3 years because he is being reinstated. That means he is being put back into the same position where he was. He cannot be promoted. Labor court cannot grant promotion, but labor court only can put back the person to the same position where he was 3 years back or 4 years back. But the till the time the dispute is pending, even if it's after 15 years, after 15 years also the labor court has to put back to the person to the same position. But he cannot say that ki now since at 15 years before the person was a manager, so after 15 years the person has become vice president of the company. That does not happen. He will be reinstated back as a manager, but what the labor court gives is all the wages of those 15 years and consequential benefits. When I say consequential benefits, then for those 15 years the employees who were similarly placed like the workmen must have got some increment, must have got some bonus, must have got promotion. So those consequential benefits have to be given by the management. So that kind of a judgment is delivered by the labor court. So inquiry report should analyze an evidence and reason findings. Similarly, labor court gives a arrangement. Copy of the inquiry report must be supplied to the delinquent employee. Similarly, once labor court gives the judgment award or order, copies are sent both to the workman and management. Before passing any disciplinary order, it is advisable to show cause the delinquent employee against the proposed punishment. This only happens in the domestic inquiry. So, your termination order by the company should always precede with a show cause notice so that to prove to the court, when it goes to the court, when the termination is challenged in the court, to prove to the court that, principles of natural justice was followed, audi alter partem was followed. What is audi alter partem? Audi alter partem is that you are giving opportunity of hearing to the party, to the other party. So audio order fatum is followed, and sufficient opportunities were given to the party, to the delinquent employee to prove his case. So termination should order which must be accompanied with full and final settlement. So generally there are cases which says that I've been terminated, but my full and final settlement has yet not been done. So in those kind of cases, courts have come down heavily on the employer that there is a enactment which says within 2 days the term after termination has been done, the full and final settlement should be done. Then why the employer has not paid it even after a month? So this goes very against the company. These are the nitty gritties which goes is looked into by the labor court. This is So to sum it up, there are two legs of industrial adjudication when it comes to under labor laws. One is under the Industrial Disputes Act, and one is disciplinary proceedings. Disciplinary proceedings or domestic inquiry only stems into the industrial adjudication cases. So if the foundations are correct, then the defending the case in labor court becomes easy. So now that I'm over with my presentation, so any questions anybody needs to ask?
Thank you so much, ma'am. As you mentioned, we can just open the floor for any questions.
Yeah,
So,
yeah.
if anybody has any questions, please put them in the comments. Ma'am, if you don't mind, can we wait like another 15-20 seconds just in case somebody's typing?
Sure, sure.
Uh, Ma'am, I don't think there are any questions for now. So maybe we can end the session. But before we do, I would just really like to thank you for taking your time out and contributing to the project. It really means a lot to us at the Laws Eco team and to all of our participants. Thank you so
Thank
much.
you, Kashish. Pleasure is mine. If I would have had the opportunity to interact, that would have been a better way because these are all practical
Yeah.
field. It's giving something very academic is impossible. But still, I tried to. There were interactive sessions are much better where
Yes.
you questions are asked because unless and until these people if they are really students and they go to the court then only they will understand what I was
Yes.
referring to, and if somebody may have done internship and all they would definitely understand that and they could have come up with questions.
Yes.
Academically, if I can get a if they could have given me a course or another topic which is more related to their code, that could have been more beneficial to them, I suppose.
Yes. Oh, but thank you so much. Regardless, I mean, it becomes a little difficult to interact since it's YouTube, but like it just
Yeah,
has a better reach. So
yeah,
we usually try that.
no issues.
Wow.
Thank you, Kashish. So I'm leaving the studio for now.
Yes.
Thank you.